The defectors have a personal consequence that they get out of the house, that their seats become vacant. But equally, we cannot gloss over the fact that the defection affects the stability of the government itself. And how does the governor, as the head of the state, ignore the consequence of...
Where is that question that arises here, Malaz? Where is that question, please? How does it arise here? How did the governor didn't look at all this, what your lordship were putting to me? Ask for the records. So, Malaz, why go into a hypothetical situation, Malaz? With the greatest respect, Malaz, your lordships have so much experience. Let's not tread into areas which we are not called upon to tread upon. We are here as to how 39 or whatever, 34, go to the governor, and the governor recognizes the 34, knowing that they are in the Shiv Sena. There is the leader of the Shiv Sena, they recognize Uddhav Thackeray. He recognizes the split and administers an oath of office. How does all this enter into this, into the reckoning here?
As a principle, you are saying that the governor could not have got into it, has not got into it.
Yes,
number one.
Yes, it's not. Yes.
And the premise for that is that the governor cannot do it constitutionally.
That's right.
It should not.
That's all that your lordship is to consider. And I can understand, I can understand a situation. There can be another hypothetical.
So once there is an existing government, according to you,
yes,
which this was not a government formation for the first time.
That's correct.
Then the governor, short of a no confidence vote which is brought on the floor of the house,
yes,
the governor must ensure that the existing position continues until somebody brings a no confidence vote.
That's the only way. Now your lordships have laid that down. No longer parading, no longer comparing signatures, all that is over. So if they think, if the BJP thought that we had lost confidence, they should have moved a motion.
That is because of Bommai, which said that it's only the floor of the house.
That's correct. So you move a no confidence. How do these issues come in at all? There's no discretion.
So according to you, as a matter of principle, absent a motion of no confidence,
that's right,
the governor must continue with the existing position.
That's correct, because there's an elected government.
Right.
Now this is much worse, that he recognizes the split and administers the oath of office.
And thereafter the floor test was subsequently.
Yes.
That is on 4th.
Yes, on 4th.
3rd or 4th.
Including those 39.
But there, so far as speaking for myself, can the governor, correct? Because under the 10th schedule, it is for the speaker to take a decision.
Right.
Correct? Can the governor, correct, on his own, without any disqualify, the speaker can take cognizance that they are disqualified?
Your lordship is right, absolutely right, but they are still the Shiv Sena. That question will still have to be answered. What is that? What are the 39? They are still the Shiv Sena. So then he recognizes the split. That's the problem. That's why the 10th schedule, that's why the whole paragraph, this is the issue. When 3 was eliminated, it was only for the purposes, deleted, it is only for the purposes, majority or minority, you can't destabilize an elected government. And constitutional morality was the linchpin. And that's why I told your lordships, ideally the governor should have said, no further action, get your disqualification decided, then I will see. I told that to your lordships earlier.
But suppose the speaker doesn't decide. Listen. Suppose disqualification questions are not decided at all. In the meantime, the governor is satisfied. Correct?
He
on the basis of the material
he
correct?
Can't. Well, that's not his job. It's the no confidence motion in the house. How is the government satisfaction after election doesn't arise? Well, I'm sorry. As a constitutional principle, it doesn't arise. Don't give that discretion to the governor. You will have toppling governments every other day. First the ED will go, then the CBI will go, then the governor will exercise discretion, and governments will be toppled.
Is on the one hand, yes, governors over anxiety saying that, okay, you prove the majority.
Right.
On the other hand, we have a speaker exercising that discretion and says, now come on, you immediately show, I will disqualify all of you. So these are the two constitutional
authorities. One is subject to judicial review, the other is not. Difference is one is subject to judicial review, the other is not.
All are subject to judicial review.
No, but once a new government is formed, if he calls for a trust, new government is formed, what judicial review?
True. Remedy is a different matter. I agree with you that there is a remedy.
Yeah.
But really speaking, it's there.
And
what we need to interpret is the scope of the jurisdiction of the governor and the scope of the jurisdiction of the speaker also.
The speaker, of course, the scope of jurisdiction is clear. He has to decide the matter.
Scope and extent.
He has to decide the matter. Second limb of it is, how does he call Eknath Shinde to administer oath of office? Normal, it's not just kindly come to pay.
I'm not saying anything right now, but factually,
Please.
yes, all right. Factually, he made an incorrect statement that there was no input given to the governor. There were 2 letters sent to the governor, which the governor has referred to in a letter to Mr. Uddhav Thackeray before he called for a floor test.
Correct,
So
absolutely.
that there is enough material for the governor to decide that this government
I
was
think
weak.
my learned friends, the question is, how do you administer an oath of office to Eknath Shinde? No, Maharaj, I can understand. There's another situation. There are multi-parties, Maharaj. Not just in this case. There's in several states, Maharaj, we have a multi-party system. Several parties come together. And Maharaj, suddenly a no confidence is moved. Maharaj, or somebody seeks, and in the meantime, some disqualification petitions are pending. At that stage, the governor doesn't bother about the disqualification petitions. There's a no confidence. These fellows will vote. Can you see, Maharaj, the consequences? We'll take the 39 to be validly members of the House, not disqualified. Disqualification petitions pending. Move a no confidence motion. Now, they can't move a no confidence motion because the 39 will be subject to the whip. So they know that they don't have majority. Therefore, what do? 39 go to the governor and say that now recognize me. So please appreciate, Maharaj, the way to ensure that the government falls is to move the no confidence. Why did they not move it? They could have, the 39 could have voted, they are members of the legislature. They did not move it because they knew that they are part of the Shiv Sena, subject to the whip. The government will sustain, will not fall. So the only way out was this conspiracy. And that was hatched much earlier. That's how they went to Gujarat and Assam. Having done that, they wrote that letter which I read to your lordships, Maharaj. I've read that letter that, this present government, the party members are very unhappy with it. We have been not following the ideology of Bala Sahib. All that letter I read to your lordships, Maharaj. And then they go to the speaker. So whether it's majority, minority, it really doesn't matter, Maharaj. So how could the trust vote be called? Trust vote means that you have prima facie lost confidence. Governor knows that this government has not. Why we go into the matter, Maharaj, that the governor will presume that these people will be disqualified. Why do we even presume that? They are qualified till such time as they are disqualified. So move on no confidence. So, Maharaj, your lordships must ask the question, why they didn't do that? And Maharaj, let me put it this way. If they were so concerned, Maharaj, they should have voted against the whip. They should have voted against the whip. I'm done with this issue, Maharaj. Now just 2 more issues and I'm finished, Maharaj. Number 1, your lordships have now noticed that Gogavale was appointed as the whip from Assam. If your lordships agree with me as a proposition of law that the whips cannot be appointed in this fashion, ultimately the speaker, once that government is formed on the 3rd, recognizes Gogavale. And then our legislators are issued a notice for disqualification. If your lordships agrees with my proposition of law that whips cannot be appointed in this fashion, then our notices should be quashed by this court. The problem arose that we told the commission that if you take this test of organization and representation in the legislature, you necessarily will have to include 38 or 39. And therefore, if you take that into account, your outcome, your result may be that they get the symbol. But that very matter is pending before the Supreme Court about the disqualification of these 39. So please stay your hands and let the Supreme Court decide. Now, I personally feel, Maharaj, that was not it was not antithetical to your lordships' order of stay. After all, the Election Commission has also to decide in accordance with law. The result was, this is again the sad part of it, the result was the commission says, I'm not going to bother about the organization. These 39 members are majority, therefore they get the symbol. In fact, your lordship's order was misused.
But we are not considering the validity of the order passed for the election.
No, I'm not asking, Maharaj. I'm really saying the commission said, the High Court said, Supreme Court has said no stay, therefore they have to decide.
That is to be tested in those proceedings, no?
No, that's not. But kindly see the consequences, Maharaj. Kindly see how we are hurt. That's why the reference, what is the scope of powers of the Election Commission in respect of determination split within the party. I'm not, your lordship's passed, rightly so, according to me, that let the commission, but the commission doesn't have to, can't disregard basic principles that you are giving symbol to a party on the strength of those 39 whose disqualifications are pending.
And that issue is pending before this.
That's pending. And I said to them, please stay your hands. They said, no, but Supreme Court has said that we have to go on. That's how the symbol is given. See that injustice caused to us. Says when, lordships have it, when the commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. I'll just stop here. So the jurisdiction of the commission starts when there is a claim that there are rival groups within the party. And it must have evidence in its possession, information in its possession, and must be satisfied with the information that is in their possession, that they are rival groups. Now, your lordships have seen the correspondence 21st June onwards. There is not a whisper of any rival group. Not a whisper. It's only the 39 sitting there.
So, just to rephrase it, according to you, there was no information in the possession of the EC to show that there are rival groups, and it has to be satisfied.
Yes. Now, the petition.
Can you just rephrase your submission, Mr. Sibal, again on this point?
I'm saying, the jurisdiction of the commission will commence when the commission has it in its possession information on which it is satisfied that there are two rival factions within a political party.
Right. And in this case, what is the...
Now let's kindly see. Therefore, in the context of this 10th schedule, now just that proposition. In the context of the 10th schedule, the only way you can get a symbol is when there are two rival factions within the party. It has nothing to do with the 10th schedule.
No, this has nothing to do with the 10th schedule.
Correct.
Right. So, there has to be a faction emerging. Take, for example, majority of the people in the 10th schedule are with Thackeray. Let's assume all 55 are with Thackeray. Then also para 15 can be invoked
By somebody making an application.
Because 15, para 15 refers to the party.
That's right. So, the split
refers to
correct. The split has to take,
I'm
agreeing. I'm saying exactly. That split has to take place within the party.
Right.
That split did not take place on 21st June or immediately thereafter. Never took place. A petition is filed on the 19th of July.
Correct. 19th of July.
Just note that.
19th of July.
19th of July.
19th of July, absolutely.
Correct.
Right.
And on the 18th of July, it is alleged, what is submitted along with the petition is minutes of meetings. Now, what do you have here? No time, no place, no date is given 18 July, no summons. I suppose this is a meeting of the Pratinidhi Sabha of the Shiv Sena. So it must be known to everybody where the meeting is going to be. Summons must be sent like we sent to them, right? What they do is they give a translation of the minutes of the Pratinidhi Sabha. And in the minutes, they show some resolutions have been passed. Minutes, as your lordship will know, is after the meeting. It can't be before the meeting, right? It has to be after the meeting. So there is the minutes of the Pratinidhi Sabha. And there are also minutes of the Karyakarni that your lordship will see at page 10. Again, minutes. Again, when it is held, what time is it held, where it is held. Yes, they say it happened, it is held in Bombay. I guess, someplace in Bombay. They must have known. Now, so 2 minutes are placed before the Election Commission. These 2 minutes.
Subsequent minutes also of what date? 27th?
27th of July. That's even more interesting. Well, just note the note 27 July. And then go back to the petition that they filed. It's very interesting. These are the 2 documents that they placed, nothing more. Plus, of course, appointment of people. We're not into that. Convenience volume 2. Page volume 2. Convenience volume 2. Yes. Kindly see page PDF page 699. Paragraph 8. Sorry. 698. Where is that? Yes. 698. Romans 626.
Page?
PDF page 698. This petition is filed on the 19th of July. Just mark that, Malaj. This averment is made when the petition is filed on 19th July.
What is the page number?
Page number.
698, Malaj. PDF 698.